Mr. Greaves, stop right there. Step away from the car.
What is this about?
The Children's Trust, Marcus. 4 million gone.
Am I being detained?
For 6 years, Marcus Eldon Greaves was the only adult standing between 3 orphaned children and the $4.2 million left behind when their parents died. The probate court trusted him completely. Not one person checked.
Your shell company, the lake house, the boat, all of it theirs.
Then I have nothing further to say, and I want that noted right now.
He would never see his lake house again as a free man. Within 72 hours, state investigators would seize 11 boxes from his downtown Hartford office, freeze 6 bank accounts, and open 2 identical-looking binders on the same evidence table. One held the children's real futures. The other held the version he handed the judge every year for 6 years. $4 million. 3 orphaned siblings. One trusted man appointed by the court to protect them, and a boat, a lake property, and a mortgage that only existed because the money belonging to a 4-year-old, a 9-year-old, and a 13-year-old had bled quietly into a shell company for over half a decade. Before we go any further, I want you to think about something. Have you ever handed control of something you loved to a person the system itself told you to trust? A court-appointed anything, a financial advisor, a guardian. Drop a comment and tell me who you handed it to and whether they earned it. And if you're not subscribed yet, do that now. This channel covers the case's mainstream news. Let's fade quietly every single week. Marcus Eldon Greaves was born in West Hartford, Connecticut on February 3, 1970. His father, Eldon Greaves, was a claims adjuster for Aetna. His mother, Helen, taught 5th grade at Charter Oak Elementary. The family lived in a 3-bedroom colonial on Prospect Avenue, 1 block from the reservoir. Marcus was the older of 2 children. His sister Marjorie was born 4 years later. The Greaves household ran on paperwork. Eldon brought home yellow claims folders in a leather satchel every evening. Helen graded compositions at the kitchen table. Marcus grew up watching his parents move documents from one pile to another with a quiet, ordered kind of authority. He learned early that a well-kept file could decide who won and who lost. He was the child who alphabetized his own bookshelf without being asked. He attended Hall High School, where he ran cross-country and served on the mock trial team. His junior year mock trial coach, a local attorney named Peter Halloran, wrote him a letter of recommendation for college that described him as, quote, unusually careful with facts, and the kind of student who reads footnotes. Marcus kept that letter in a drawer for the rest of his life. He graduated from Trinity College in Hartford in 1992 with a double major in economics and philosophy. He was accepted at the University of Connecticut School of Law that same year on a partial scholarship. He worked summers doing document review at a mid-sized insurance defense firm on Constitution Plaza. He passed the Connecticut bar in '95 and, 6 months later, sat for and passed the Uniform CPA exam. The dual credentials would define his entire career. His first job was as an associate at Whitfield Halloran and Cross, a downtown Hartford firm that handled probate and trust litigation. The starting salary was $52,000. His first assignment was to review a decade of accountings on a contested estate involving 3 siblings who could not agree on the sale of a family cottage. He billed 147 hours reconciling the numbers. The senior partner, a man named Denton Cross, wrote in his year-end review that Marcus was the most patient young lawyer he had supervised in 20 years. That review also used a phrase Marcus would hear repeated for the next 15 years. Trustworthy to a fault. He made partner in 2003. He married a Wesleyan graduate named Caroline Vance in the fall of 2004. Their son, Nathaniel, was born in 2007. By his mid-30s, Marcus was the associate the firm assigned to the delicate cases, the widow who could not manage her own affairs, the estate where 2 children were in litigation with a stepmother, the conservatorship where the ward had early onset dementia. Judges started asking for him by name. In 2010, Marcus left Whitfield Halloran and Cross and opened Greaves Fiduciary Services, LLC, in a 4th-floor suite on Trumbull Street, 2 blocks from the state courthouse. He hired a paralegal, a bookkeeper, and eventually a junior associate. His firm managed conservatorships, special needs trusts, and minor beneficiary accounts. He sat on the board of the Hartford Legal Aid Society, and later, the Ethics Committee of the Connecticut Bar Association. He taught a continuing education seminar for lawyers seeking to renew their fiduciary certifications. The seminar was titled The Sacred Trust. He had taught it every fall since 2014. For 22 years, the record on Marcus Eldon Greaves was clean. No client complaints, no bar grievances, no probate court sanctions. 3 separate probate judges in Hartford County kept a short list of attorneys they were willing to appoint when a case involved orphaned children or an incapacitated adult with no family. Marcus's name was on all 3 lists. That trust was about to be tested by the worst tragedy the Aldis family had ever known. Every year in Connecticut, hundreds of wrongful death settlements involving minor beneficiaries pass through the state's probate courts. When a child inherits money in Connecticut, the money does not go to the child. It cannot. Minors cannot own significant assets outright. The money goes into a court-supervised trust, and the court appoints a fiduciary. That fiduciary, usually an attorney, sometimes a CPA, occasionally a bank trust department, becomes the legal owner of the funds on the child's behalf. The fiduciary's obligations are precise. He must invest the money prudently. He must pay reasonable expenses for the child's benefit. He must file an annual accounting with the probate court, listing every deposit, every withdrawal, and the current balance. He must maintain custodial statements from a licensed brokerage. He may charge reasonable fees for his services, but those fees must be disclosed and approved. The probate court, in turn, is supposed to review those annual accountings. In Connecticut, a probate judge reviews thousands of trust accountings a year. Each one runs anywhere from 12 to 60 pages. The review is largely a paper exercise. If the numbers add up on their face, if the custodial statement matches the accounting, and if no interested party has filed an objection, the accounting is approved as a matter of course. The system is built on 2 assumptions. The first is that the fiduciary will not lie. The second is that if he does lie, someone, a co-trustee, a guardian, a beneficiary, will eventually notice. In the Aldis case, both assumptions failed at the same time. On a rainy Tuesday evening in April of 2019, a semi-trailer jackknifed on Interstate 84 outside Vernon. The car directly behind it, a gray Subaru Outback carrying Daniel Aldis and his wife Catherine, home from a school function, was struck by the trailer's cab and driven into a concrete median. Daniel was 39. Catherine was 37. Both were pronounced dead at St. Francis Hospital in Hartford. Their 3 children, Elias Jasper Aldis, age 13, Nora Aldis, age 9, and Toby Aldis, age 4, were at home in New Britain with their Aunt Denise, who had come over that evening to babysit. A wrongful death settlement against the trucking company and the parents' combined life insurance payout produced a total of $4.2 million for the 3 children. Under Connecticut law, that money could not simply be handed to a 13-year-old, a 9-year-old, and a 4-year-old. The Hartford Probate Court set the entire sum into a court-supervised minor beneficiary trust and appointed a sole administrator. The judge on the case pulled a name off the short list: Marcus Eldon Greaves. The children's maternal aunt, Denise Aldis, was named guardian of their persons. She had authority over where they lived, what school they attended, and what medical care they received. She had no authority over the money. She received a monthly stipend for their household expenses, which arrived on the first of every month like clockwork. The trust paid their private school tuition, their orthodontist, their summer camp fees, their pediatrician. Every bill was paid in full and on time. Denise Aldis was a paralegal at a small firm in New Britain. She was intelligent, careful, and grieving. She had lost her only sister and her brother-in-law in a single night. She had inherited 3 traumatized children and a house on Vine Street she had never expected to live in. The last thing she was equipped to do in 2019 was audit a court-appointed fiduciary. She trusted the system. She trusted the judge who had made the appointment. She trusted Marcus Greaves, who came to her kitchen with a leather portfolio and explained, gently, that the children would be taken care of and that she could focus on being their aunt. She would not question the arrangement for 6 years. The first invoice arrived in October of 2019. It listed 42 hours of estate administration, tax planning, and fiduciary review at $375 an hour. The total was $15,750. The invoice was addressed to himself in his capacity as trustee and paid from the trust account. No one else needed to approve it. The probate court would not see the itemized bill for a year. By the following spring, the hourly rate on the invoices had climbed to $425. By the end of 2020, Marcus was billing the Aldous Trust for more than $22,000 a month. The trust required no active management. The children's expenses were paid through automated ACH transfers. The investment allocation, on paper, had not changed. There was, in truth, almost nothing to do. He did it anyway. In April of 2020, Marcus formed a Connecticut limited liability company called Chartwell Diversified Holdings, LLC. The registered agent was a mailbox service on Farmington Avenue. The sole member, listed on the operating agreement filed in a locked drawer in his office, was Marcus Eldon Greaves. He opened a business checking account at a regional bank in Litchfield County and deposited $100 to activate it. On May 11th of that year, he wired $840,000 from the Aldous Trust custodial account to Chartwell Diversified Holdings. On the internal trust ledger, he recorded the transfer as, quote, reallocation to conservative bond fund vehicle. He then generated a fabricated brokerage statement on Chartwell letterhead, showing the funds invested in a mix of municipal bonds and treasury notes. The letterhead was designed on his firm's own copy of Adobe InDesign. The signature block belonged to a fictitious fund manager named Alan Reeves. There was no Alan Reeves. By 2022, roughly $1.6 million had moved from the Aldous Trust into Chartwell. From Chartwell, the money moved outward. $912,000 went to the down payment and mortgage on a lakefront property on Bantam Lake in Litchfield County. $240,000 purchased a 38-foot Chris Craft cabin cruiser docked at the Bantam Lake Yacht Club. Roughly $300,000 flowed into the operating account of Greaves Fiduciary Services, LLC, to cover payroll, rent on the Trumbull Street office, and a growing balance on a business line of credit at Webster Bank. Meanwhile, the children's real expenses were paid on time and in full. Tuition at Kingswood Oxford School, braces for the middle child, a pediatric neurologist for the youngest, who had struggled with anxiety since the accident, summer camp in the Berkshires, new winter coats, a used Honda Civic when the oldest turned 16 and got his learner's permit. Denise received her stipend on the first of the month, every month. The children had a laptop each, a private tutor for the middle one, and a debit card apiece with a modest weekly allowance. Not a single bill was late. Not a single request from Denise was denied. And that was the point. A quiet household is a household that does not ask questions. Each October, Marcus filed the annual accounting with Hartford Probate Court. Each accounting showed a trust balance growing modestly year over year, in line with a conservative fixed income allocation. Each was supported by a printout of a custodial statement from Chartwell Diversified Holdings, bearing the fictional Alan Reeves' signature. Each was reviewed by a probate judge and approved as a matter of course. No interested party filed an objection. No interested party knew there was anything to object to. The oldest sibling, a young man the family called Jasper, though his given name on the trust was Elias Jasper Aldous, did not know his parents had left him anything specific. Denise had told him only that his college would be paid for and that his parents had loved him. She did not want a 14-year-old, and then a 15-year-old, and then a 16-year-old, to grow up thinking of himself as a boy with a trust fund. By the fall of 2024, Jasper was 17 years old, a senior at Kingswood, and applying to college. He would turn 18 the following August. Under the terms of the trust, his first partial distribution, $250,000, earmarked for undergraduate tuition, was scheduled for release the day after his birthday. Marcus Greaves knew, on that fall day, that the trust held approximately $188,000 total across all three children. He did not tell anyone. In February of 2025, Jasper Aldous received an acceptance letter from Boston College with a partial merit scholarship. The scholarship covered roughly a third of tuition. The rest, approximately $68,000 for the first year, including room and board, would come from the trust. The BC Financial Aid Office required documentation. Jasper submitted the standard paperwork through his aunt: a federal aid application, a certified copy of the trust instrument, and a form signed by the trustee affirming that the tuition disbursement would be paid directly to the university on a semester basis. Marcus signed the form on March 12th. Denise mailed it along with the other documents. 3 weeks later, a financial aid counselor at BC named Priya Sundar sent a follow-up email to Denise. The email was cordial and confused. The counselor noted that the trust documentation the family had provided listed a total anticipated distribution of $650,000 across 4 years, but the trustee's certification had noted only $250,000 in currently available first-year proceeds. The counselor wanted to confirm which figure was accurate. Denise called Marcus the same afternoon. Marcus was patient on the phone. He explained that the trust was in a repositioning cycle and that the second year and beyond distributions would be released as market conditions stabilized. He used the phrase prudent staggering. He assured her the children were fully protected. He told her not to worry. Denise, for the first time in 6 years, did worry. That night, at her kitchen table on Vine Street, she pulled out the accountings Marcus had provided her. Courtesy copies, unsealed, that she had never previously scrutinized. She had a paralegal's eye. She had spent 15 years reading estate documents for a small firm in New Britain. She began to compare the annual balances against the projected distributions listed on the trust instrument. The math, she realized, did not work. If the fund had grown, as the accountings claimed, there should be significantly more than $650,000 available across the 3 children. She called the custodian listed on the accountings, Chartwell Diversified Holdings, and got a voicemail. She called again the next day. Voicemail. She Googled the address on the letterhead and found herself looking at a Google Street View image of a UPS store on Farmington Avenue. She called a lawyer. The lawyer's name was Ellen Bautista, a former state prosecutor now in private practice in West Hartford. Bautista listened to Denise for 45 minutes and then made a single phone call. She called Fidelity Investments, the licensed brokerage listed on the original 2019 trust instrument as the custodian of record. She asked for the current balance and the year-to-date statement. The Fidelity representative confirmed the account existed, confirmed Denise's authority to receive the statement as guardian, and emailed it within the hour. The account held $188,412. Denise Aldous, sitting alone in her office in New Britain, understood what had happened before Bautista said a word. We are about to get into the arrest, the search warrant, and the 2 binders. Before we do, I want to say this. If you have made it this far, it is because this story deserves to be told properly, and this channel does not let stories like this get buried. Subscribe if you want to see how the system handled a man it trusted for 22 years. We break down every single detail. Ellen Bautista contacted the Connecticut Statewide Prosecution Bureau on April 8th of 2025. Within 2 weeks, the case was assigned to a senior assistant state's attorney named Rachel Kaminsky, who specialized in fiduciary and financial crimes. Kaminsky coordinated with a forensic accountant from the office of the chief state's attorney, a certified fraud examiner named David Ung. Ung's first task was to subpoena the underlying Fidelity records for the Aldous Trust custodial account. What he received in reply was a complete transaction history going back to the original 2019 deposit. What he did not receive were any statements from an entity called Chartwell Diversified Holdings, because Fidelity had no record of any such transfer. The $840,000 wire in May of 2020 had gone out to a small regional bank in Litchfield County, not into a bond allocation. Ung followed the money. The trail led directly from the Aldous Trust to Chartwell. From Chartwell to a title company handling the closing on the Bantam Lake property. From Chartwell to the Bantam Lake Yacht Club Marina. From Chartwell into Greaves Fiduciary Services' business operating account at Webster Bank. Ung mapped 17 separate transfers over 5.5 years. The pattern was consistent. Trust funds moved into Chartwell in six-figure increments. From Chartwell, they moved outward into Marcus Greaves's personal enrichment and business obligations. There were text messages, too, recovered later from Marcus's law firm laptop. Most were mundane, but 3 exchanges with his commercial banker at Webster stood out. Greaves, June 9th, 2022. We're going to need another draw against the operating line by month end. Can we push the Chartwell reallocation through Thursday? Banker, June 9th, 2022. Same routing as last time. Confirm the memo line. Greaves, June 9th, 2022. Same memo. Client bond reallocation. Standard. Greaves, February 14th, 2024. Reeves is out of pocket this quarter. I will handle the statement generation on this end. Banker, February 14th, 2024. Understood. Ung flagged the phrase statement generation for Kaminsky. Marcus had not written that a report was being requested. He had written that it was being made. On May 9th of 2025, a Hartford Superior Court judge signed a search warrant for the offices of Greaves Fiduciary Services on Trumbull Street. The search team arrived at 7:15 in the morning. Marcus was not yet in the office. His paralegal, a woman named Beverly Chun, who had worked for him for 11 years, opened the door. She read the warrant. She sat down in the reception area and did not speak for the next 4 hours. Investigators seized 11 boxes of files, 4 computers, 3 external hard drives, and the contents of a locked lower drawer in Marcus's private office. Inside that drawer, wrapped in a rubber band, was the Chartwell operating agreement listing Marcus as the sole member. Beside it was a manila folder containing draft custodial statements on Chartwell letterhead, several of them incomplete, showing the version of reality Marcus filed with the probate court. But the piece of evidence that would define the case was found in a fireproof cabinet in the firm's back office. 2 binders, identical navy blue leather, identical embossed labels reading Aldous Family Trust, Annual Accountings. 1 binder contained the genuine Fidelity custodial statements. The other contained the fabricated Chartwell statements, same logo, same fonts, same tabbed sections, same handwritten notes in the margins in Marcus's own tight cursive. Placed side by side on Ung's evidence table, they told 2 completely different stories about the same 6 years. In one binder, the trust was healthy and growing. In the other, the trust was bleeding out. Marcus Greaves had kept both binders, because at some point, in some quiet moment, he had needed to remember which lie he had told. On the morning of May 16th, 2025, Marcus Eldon Greaves arrived at his office at 7:52, carrying a leather satchel and a coffee from the shop on the corner of Trumbull and Pearl. 2 state investigators were waiting in the reception area. Beverly Chun was already at her desk. She did not look up. The lead investigator, a detective sergeant named Miguel Ortiz, stood. Ortiz. Mr. Greaves. Marcus Greaves. Greaves. Yes. Ortiz. Sir, I have a warrant for your arrest. First-degree larceny, forgery in the first degree, criminal impersonation. Can you set the coffee down, please, and turn around? Marcus did not move for several seconds. He looked at the coffee in his hand. He looked at Beverly, who still would not look up. He looked at the framed diploma on the wall above the reception desk, a University of Connecticut School of Law parchment from 1995 that had hung on that wall for 15 years. Greaves. There's been a misunderstanding. His voice was steady. His hand was not. Ortiz. Set the coffee down, sir. Greaves. I need to call my attorney. Ortiz. You can call your attorney from the vehicle. Turn around, please. He turned around. The second investigator took the leather satchel out of his other hand and set it on the reception desk. The handcuffs closed at 7:55. Greaves. Beverly, please cancel my 9 o'clock. Beverly Chun looked up for the first time. She did not answer. She waited until the elevator doors closed. Then she picked up the phone, called the Connecticut Bar Association, and asked to be transferred to the Ethics Committee. The 9 o'clock appointment had been a widow from Manchester, referred to Marcus by her deacon, whose husband had died in February. Marcus Eldon Greaves was arraigned in Hartford Superior Court on the afternoon of May 16th. Bail was set at $2 million. His attorney, a well-regarded criminal defense lawyer named Grant Priebus, argued that Marcus had lifelong ties to the community, no prior record, and posed no flight risk. The state pointed to the Bantam Lake property, the boat, and the Shell LLC. The judge left the bail as set. Priebus posted bond by the following Monday, using the equity in Marcus's Prospect Avenue home as collateral. Marcus surrendered his passport, his Connecticut bar license pending review, and his CPA certification. Greaves Fiduciary Services, LLC, was placed into a court-supervised receivership. Beverly Chun and the junior associate were terminated by court order and paid 2 weeks' severance from firm reserves. Within 30 days, the state indictment was expanded. First-degree larceny under Connecticut General Statutes, Section 53, A-122. Forgery in the first degree under Section 53, A-138. Criminal impersonation under Section 53, A-130. In parallel, a federal grand jury in the District of Connecticut returned an indictment on 29 counts of wire fraud under 18 U.S.C. Section 1343, based on the interstate wire transfers between the Fidelity custodial account and the Chartwell Shell. The probate court moved separately. Judge Amelia Renshaw, who had signed each of Marcus's annual accounting approvals for 6 years, issued an order removing him as trustee and freezing his personal assets pending a surcharge proceeding. Her written opinion, 4 pages long, contained a paragraph that would be quoted in the Hartford Courant and read aloud at a state bar ethics forum later that summer. Renshaw wrote, quote, "This court appointed the defendant precisely because we trusted him. That trust was not general. It was specific, and it was solemn. 3 children, having lost their parents in a single instant, were placed under this court's protection, and this court, in turn, placed them under the defendant's. Every safeguard the law provides for orphaned minor beneficiaries flowed through one man. That was the structure. That was the flaw. And that, if the state's allegations are proved, is what the defendant exploited." End quote. Marcus Greaves has pleaded not guilty to all charges. The case is pretrial. As of the writing of this account, no conviction has been entered. Every allegation described here comes from the indictment, from prosecutorial filings, and from the probate court's surcharge motion. Marcus's defense attorney has publicly stated that his client, quote, categorically denies wrongdoing, and that the accountings will, quote, ultimately be shown to reflect legitimate, if aggressive, fiduciary judgment. No trial date has been set. The Aldis siblings remain with their aunt in New Britain. Denise Aldis, through Ellen Bautista, has filed a civil action seeking recovery from Marcus personally, from Greaves Fiduciary Services, LLC, in receivership, and from the malpractice carrier that covered his firm. The lake house on Bantam Lake has been listed for sale under court order. The Chris Craft cabin cruiser was towed from the marina on the morning of June 3rd. Jasper Aldis is scheduled to begin classes at Boston College this coming September. His tuition will be paid through a combination of the Merit Scholarship, federal loans, and a private grant established by an anonymous Hartford donor after the story reached the Courant. He does not intend to major in economics or philosophy. He wants to be a public defender. The last thing Marcus taught in his ethics seminar, the fall before the arrest, in a conference room at the Connecticut Bar Center in New Britain, was the concept of the sacred trust between a fiduciary and a beneficiary who cannot speak for themselves. 14 attorneys attended. He was paid $1,200 for the lecture. Denise Aldis saved the ethics seminar brochure. It sits in a folder in her paralegal cabinet in the drawer marked Aldis, above the surcharge motion and beneath the fidelity statement that ended it all. That case was cold, but the case right here on the side of your screen involves a betrayal so precise, so quiet, and so cruel that it will follow you for the rest of the week. Click it now.